Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, I'm keeping the clock this morning. I can keep you apprised of the passage of time.
Thank you, Your Honor.
Thank you. We've read the briefs. We are ready to see the vote.
May it please the court, Robert Kroc from the law firm of McCarthy, Levitt, Crystal, and Lifman from Cleveland. I represent Surrey Medwick Acquisition LLC, the defendant appellant in this case. It's a commercial foreclosure case. It's not as dramatic as the two cases that came before us, but it has to do with the right or entitlement of the plaintiff, U.S. Bank, to foreclose a commercial mortgage on property that's located here in Medina. In case the court wants to know, it's over on North Court Street. There's an empty Kmart. Oh, is that way? Sorry. Kmart in the middle and two strip centers on the side. Surrey Medwick owns the strip centers on each side. Before I get into the argument on the merits, I want to discuss the motion to dismiss that was filed. It should be denied for two reasons, because the case is not moot, because of the fact that there was a sale and confirmation of the sale. First, Surrey's raises in essence, jurisdictional argument similar to Schwartzwald that goes to whether or not the court's jurisdiction was properly invoked in order to proceed, and that goes to the standing of the plaintiff to invoke the jurisdiction. So if Schwartzwald recognized the right of the homeowners to not only challenge the standing, but also to take it up to appeal to the Court of Appeals level and the Supreme Court level, then, and if mootness would apply there, we'd never have a Schwartzwald decision.
Well, and you know, I thought about that, and going back and looking at the Ohio Supreme Court case, they didn't really address the mootness issue.
I agree. But most of the recent cases are situations where you've had a sale of the property. And so the mootness argument, I think, would not, if it was brought to the Supreme Court's attention, they would rule in favor of entertaining the appeal that mootness did not apply. Because it goes to I think the decision in Schwartzwald says, if the court didn't have jurisdiction, then everything that happened is a nullity. It's not like there was some...
Oh, I understand that, but I guess where I'm still having a problem, whether we're right or we're wrong, this court has taken the position that, you know, after the sale and confirmation distribution of the funds, that the issue is moot. I realize that there are other courts of appeals that take a contrary position, but that's the position this court has taken. So I'm just trying to figure out, maybe you are just asking us to re-examine our case law in this.
I am. There's 2 points here, and that's one of them. Because there's no way we can argue that there wasn't a sale, or that it was not confirmed. And we also have an assignment of error relative to the confirmation defects there as well. And that's the second point on mootness, is that this court, during the first appeal, because this is the second one, the first appeal was dismissed because it wasn't a final order, we had raised an objection in the trial court to the, in essence, validity of the order that they were seeking to undertake a sale, a share sale, brought it to the trial court's attention. This court then, through the magistrate, notified the parties that there was an issue relative to finality, and they asked us to brief it. Both parties briefed the issue to the magistrate. At the same time, we were continuing with our objection at the court level, saying Schwartzwald, you shouldn't proceed with confirmation until after the Court of Appeals hears it. And then when this court dismissed, we went back to the trial court and said, the Court of Appeals found that the order wasn't final, therefore you should not confirm a sale because the sale was done in conjunction with an order that was not a final order. The court confirmed anyways, and that's why we had then amended, if you will, our notice of appeal to include that claim as well. So for those 2 reasons, we believe that the case is not moot and the court entertained the appeal.
And I understand your arguments, but I guess my point is, there's always a good faith basis required to bring an appeal. So in every appeal we hear after a confirmation, after the cell and the sheriff's cell and confirmation, every time it's appealed, there has to be a good faith basis that the underlying foreclosure was an error. And we've always said it's moot. So that's what I'm getting at. You're giving me arguments as to why it should never have happened, and I understand that. I'm trying to figure out why it's not moot.
Well, the second component is that they proceeded with a sale on an order that was not final.
I know, but that's going to the merits of whether it should have been foreclosed on to begin with. In other words, this court has said there's no remedy, basically, it's moot, it's over with.
But if the sale is a nullity because they sold it in violation or
All right.
without a legitimate court order, that's what the contention is.
Thank you.
As to the merits, we argued that the court abused its discretion and/or the decision of the court finding that the plaintiff was a holder entitled to a holder or a non-holder in possession with the rights of a holder entitled to enforce the note and therefore foreclose on the mortgage was against the manifest weight of the evidence. In Schwartzwald, the plaintiff in the foreclosure case is required to establish that it's the owner and holder of the note and mortgage at the time the complaint is filed in order to establish that it invoked the court's jurisdiction to proceed with the case. The plaintiff has the burden of proof. The UCC sets forth the rules to determine holdership or whether or not, if you're not a holder, whether you're a non-holder in possession with the rights of possession. Those are simple rules. And the rules are, if you originated the loan, so if this case was brought by Wachovia, it had possession of the note and mortgage, there's no assignment issues because there's no third party, then it would have standing and could invoke the court's jurisdiction. If it didn't originate, like in this case, it's a trust that contends that it's the owner and holder, then there has to be certain documents that evidence how it acquired title. The evidence in this case, in the testimony, the sole witness of the plaintiff was a Mr. Demetrius Marakis, and he was employed by a service of CW Capital. And he testified that the documentation, and this was on Exhibit 29, it's like a 1,000-page, 2-volume document. That's the pooling and servicing agreement, which is identified in that document as a common law trust. And that in that document it showed that the Wachovia note was transferred to the trust, but it was without an allonge showing an endorsement from Wachovia to the trust. So under Article 3, if you want to become a holder, you have to have negotiation. Negotiation happens depending on the nature of how the parties to the transaction do it. If the transferee is going to be a named payee, you make it pay to the order of Cobalt Trust, okay, for example. And then you take that allonge and you affix it to it, and then you deliver it. So it takes endorsement, affixation, that's a word, and delivery in order to have a negotiation. If you have that, you have the party holding the papers and a holder. Okay? You can also do it by making it out in blank, and if you have possession with the allonge, then you have, you're also a holder. If you don't have a holder, but you're in possession of the note, you may be able to show that you're a non-holder in possession with rights of a holder. But in order to do that, you have to demonstrate how you acquired it and show that all steps in the chain of title were met. There was no testimony here to show that anything other than the defect that existed from the inception. You have the promissory note without an allonge, and therefore you don't have any negotiation to note from Wachovia. The fact that there's a trust here, because like I said, Exhibit 29 is the PSA. It says in the preamble, Section 2.01 of the trust document, that it's a common law trust. It identifies under that same paragraph, 2.01b, I believe it is, that the depositor under the trust is, and get the correct name here, CW Capital Funding Corporation. Okay, now depositor under trust is what we usually look at as like a settlor of a trust. They're the ones that form the trust. They're the ones that are going to contribute property into the trust. And in this case, in order for the plaintiff to have met its burden of proof to demonstrate that it's a non-holder in possession of the rights of the holder, it would have to show that there was a negotiation and transfer from Wachovia to CW Capital Funding Corporation by way of endorsement of the note to it, and then from CW Capital Funding Corporation to the trustee of the Cobalt Trust. That didn't happen. That was their burden. So they failed to meet their burden, but the court made the finding that they were a holder and/or a non-holder in possession.
Is that burden placed on them pursuant to the commercial code, or is it placed on them pursuant to the case law regarding and following for Schwartzwald?
I think it's case law interpreting the UCC and how it applies. The UCC sets out here are the requirements, and the case law establishes that the burden's on the plaintiff to establish that they are a holder, that they acquired the paper by one of those mechanisms.
Schwartzwald, correct?
Mhm.
Okay. The reason why I raised the point is that since the advent of Schwartzwald and the case law that has happened since that time, there seems to be some controversy about whether or not the Uniform Commercial Code controls this, if this note is commercial paper or not.
Mhm.
So I guess I'm making sure I understand the argument as to where the burden is coming from upon the plaintiff who wishes to foreclose
Yeah.
a note.
Because Schwartzwald says you have to be the owner and holder of the note.
Okay, go ahead.
Okay, at the time you foreclose. So it seems to be that that's imposes an obligation on the plaintiff to demonstrate that they were the owner and holder of the note and mortgage at the time the case is filed. And when you look at, if you're talking about this normal contract principles apply instead of Article 3 of the UCC, if you look at the recent case in Deutsche Bank versus Holder, excuse me, where the lenders were saying, well, we have a mortgage assignment that references the note in the language, the conveyance language. Therefore, that should be sufficient. So we don't have an allonge, we don't have any of that Article 3 stuff. We've got this. Okay, so they step in with that, and they made it very clear, in my opinion,
And-
that doesn't do it. There's a requirement, and Article 3 is the requirement.
And I don't know if you reserved any time, there are about 3.5 minutes remaining, but I will say just this with respect to Holder, Deutsche Bank versus Holder, that was a mortgage, right?
Yes.
And the question becomes, does that assist you in your arguments regarding a note? There are two different documents, one or both of which may be commercial paper or both of which may not be commercial paper. Again, that's why I was asking about the law that we would look to take the burden where it needs to be. And I wanted you to know that there's 3.5 minutes left. You may proceed or reserve as you wish.
You know, I forgot to ask for a reservation. I
That's-
apologize for that. But I think that Deutsche Bank Holder sort of clarifies, if you will, that there's a distinction between how you convey a note and how you convey a mortgage. And the case law and the statute is the UCC Article 3. I think negotiability determines, whether or not you're talking about a negotiable promissory note that may require endorsement. Okay, but that's apparently what they intended initially to do here, but didn't accomplish. Thank you.
Thank you.
May it please the court, Attorney David Van Slyck on behalf of the plaintiff, U.S. Bank National Association. I want to address the first issue raised by Judge Carr in terms of the motion to dismiss. But in that context, I want to address Schwartzwald to make sure that we're clear. Schwartzwald in paragraph 28 set forth the rule in the state of Ohio that the plaintiff has to be the holder of the note or mortgage at the time of commencement. This court in McFerrin has taken that decision from Schwartzwald and said that the lender has to be the holder of the note and mortgage at the time of commencement of a lawsuit. The lender in this case met that mark, Attached to the complaint in this case was the note with 3 allonges attached thereto, the mortgage, an assignment of rents, and 3 recorded assignments of the mortgage and 3 recorded assignments of the assignment of rents. In addition, and critically, was an affidavit from Mr. Maracas, who testified at the trial. In his affidavit, Mr. Maracas stated that the lender was the holder of the note and or the entity entitled to enforce it at the time of attestation of the affidavit, which was before commencement of the action. And it also said that Mr. Maracas, in his capacity as an employee at CW Capital, who was the servicer, was in possession of the original executed note. So the complaint, with that affidavit from Mr. Maracas, ends any myth that the complaint, or the lender in this case, wasn't Schwartzwald compliant or wasn't McFerrin compliant. It in fact was. Now, to get to the issue of the motion to dismiss, it's our position that this appeal should in fact be dismissed. And I want to address the issue of mootness and the concern that gets raised in these sorts of cases. August of 2016, the trial court issued an order adopting a March 2016 magistrate's decision. In that order, the judge specifically adopted the magistrate's decision, specifically adopted the findings of fact after making her own independent review, adopted the conclusions of law, and identified all 8 conclusions of law. But critically, she did something else. She granted the judgment on the note, and she ordered that the mortgage could be foreclosed such that the lender could submit a precipice for order of sale. So when that decision was issued in August of 2016, based on that decision, I personally filed a precipice for order of sale based on my reading of that judgment that appeared to be final and appealable. Ultimately, the court issues an order, and interestingly, I want to point out for the record that when the Court of Appeals magistrate raised the question of whether or not that order was in fact final and appealable, both the defendant and the plaintiff both said, yes, it is final and appealable. We agree that it is final and appealable. This court ultimately held otherwise. But to turn around now and vacate the sale that was based upon an order that appeared to be final and appealable, and under circumstances where this court's prior case law in false savings suggests that we could take the property to sale via an order that's determined to be interlocutory, this appeal is moot. Once that sale was confirmed, as far as we're concerned, any appeal is moot. And I raised the issue with the court. If the court opens this up to say, well, wait a second, shouldn't we get to hear the merits? The problem is, effectively, then what you're handing a defendant is an automatic stay without having to post a bond. Keep in mind, the defendant never sought a stay of execution, let alone obtained one. So to suggest that a lender, based upon an order that appears to be final and appealable, and based upon this court's prior case law, has to be permitted to proceed with its execution, particularly when the court's decision of August 2016 said, yes, you can file your precipice for order of sale. So with all due respect, I do in fact believe we are Schwartzwald compliant and that this appeal is moot. Now, to the merits. I think the defendant's argument is, don't let the case law get in the way of the story, because it's a bit of a mishmash as to the evidence that was in fact before the court. What the defendant is trying to do is 2 things. The defendant is trying to attack compliance with the pooling and servicing agreement, the PSA, and at the same time ignore the fact that the allonges were attached to the note. So the defendant is basically putting both ends to the middle. Let me address first the issue with the allonges attached to the note. At the trial, the original executed note with allonges attached to it were presented to counsel for the defendant and the court. It was stipulated in the record that, in fact, all those documents were here for the court. In addition, the only testimony before the court from Mr. Maracas on page 41 of the trial transcript, when did CW Capital Asset Management, who was Mr. Maracas' employer as the servicer, when did you acquire physical possession of the note? November 2013. So before commencement of this action, the servicer had physical possession of the original executed note with all 3 allonges attached thereto. Under UCC 130331, that renders the plaintiff the holder of the note, period. Now, what the defendant is trying to do is argue doing an end around and say, well, I think it was supposed to have been endorsed to somebody else. And it should have gone to a depositor, and the depositor then had to have it go to the trustee. What the defense is raising in that vein is trying to attack the pooling and servicing agreement. Now, there is a plethora of case law, both throughout the state of Ohio and throughout the country, that says a borrower can't attack compliance with the pooling and servicing agreement. And in the case law, all suggests that if somebody screws it up, that renders the act voidable, not void. And so the cases all suggest that the borrower can't attack a pooling and servicing agreement, that the only one that can allege a breach of that would be the certificate holders, the beneficiaries. The borrower is not a beneficiary under that pooling and servicing agreement. In fact, in this case, and there was testimony to this effect at the trial, Section 12.09 of the pooling and servicing agreement specifically says, no other person, including any mortgagor, shall be entitled to any benefit or equitable right, remedy, or claim under this agreement. This Court of Appeals has held similar language in other contractual relationships, excludes then the ability to be a third-party beneficiary to raise an issue. So this borrower can't raise an issue with compliance with the pooling and servicing agreement. Number one, it's barred from doing so, lacks standing. But more to the point, the evidence that was presented at trial was that, in fact, compliance with the pooling and servicing agreement was had in this case. Section 2.01 of that pooling and servicing agreement, B, says that the mortgage loan seller shall deliver and deposit with the trustee or custodian appointed thereby the mortgage file for each mortgage loan. Okay? And what that means is the person making the loan, Wachovia, takes the original note, it deposits that original note with the trustee, who at the beginning of this case was Wells Fargo. Wells Fargo holds the note in trust. That's exactly what happened here. And the reason we know that's what happened here is when you take Section 2.01 of the pooling and servicing agreement, add Section 2.02 of the pooling and servicing agreement, and you go to the exceptions, which are in Schedule A and Schedule B in Exhibit 29, which, as Mr. Crack summarizes, is 2,000 pages. And I've made copies for the court because...
Is it in the record already?
It is. It's 2,000 pages. And so if the court wanted copies, I brought copies of the pertinent parts. It's about 6 pages. But the point of the matter is that the record shows that the note was in fact deposited with the trustee before the closing date. That's significant because the UCC deals with that issue in 1303.22a and b. 1303.22a and b of the revised code, and I'm paraphrasing, says, look, if the note is given, possession of it is given to a third party, although that may not be a negotiation of the instrument, the possessor has the right to enforce the note as a holder. Applying that to this case, that's exactly what happens. The note is given to the trustee, trustee's holding it in trust. At that very moment, under 1303.22 of the code, the trustee's the party entitled to enforce it. The fact that the allonge comes later, and we know that it came later because it was ultimately attached to the note along with 2 other allonges, but the fact that that allonge comes later doesn't impact the negotiability or the enforceability of that instrument. The second the note was given to the trustee, that note was enforceable by the trustee. So there is no, in fact, violation of this pooling and servicing agreement. The UCC has been accounted for in this particular transaction once that note was deposited in trust. I'd further point out that the pooling and servicing agreement dictates how the allonge was supposed to have been executed. And that, in fact, happened in this case as well. The pooling and servicing agreement dictates that the trustee gets appointed and that the allonge be endorsed in the definition of mortgage file, how the note has to be endorsed. That happened in this case as well. So the argument that's being espoused by the defendant, again, pushing both ends to the middle, attacking the pooling and servicing agreement, which it lacks standing to do, or saying that the UCC was implied with is actually just mishmashing a story. The reality of the situation is this loan transaction fully complied with all pertinent parts of the UCC. Once the note was deposited with the trustee, it was held in trust. In order to dot the I and cross the T, 3 separate allonges were attached. That note with the 3 allonges was attached to the complaint with an affidavit from the servicer saying, I'm in possession of this document. And as this court well knows, the servicer has constructive possession on behalf of the true note holder. There's a plethora of case law throughout the state on that particular issue. Now, let's deal with the Holden question. Holden, the Supreme Court's, I'll give the court a quick refresher. The issue in Holden that this court faced was where there was a note attached to the complaint that said, and I'm paraphrasing, true and accurate copy. And then what happened is the lender at summary judgment submitted an affidavit. That document likewise said true and accurate copy, but the endorsement was on there. And what this court held was, well, wait a second, that must create an issue of fact. Where the Supreme Court went with that, to be very blunt with this court, I have no idea. I'm at a bit of a loss for the perception of the Supreme Court in Holden because it seems to me it's now created an issue. Particularly, the Supreme Court in Holden has now said that there are 2 remedies when dealing in a foreclosure. You have a remedy on the note and a remedy on the mortgage. And the Supreme Court in Holden said, and again I'm paraphrasing, well, if the note is unenforceable, the mortgage still might be enforceable. And admittedly, I'm not sure what to do with that particular issue. I think it creates significant issues in the enforceability of instruments in Ohio. And let me give the court a brief example. If I represent a lender in a residential or a consumer transaction and I sue on a note that's barred by a statute of limitation, I'm potentially subject to a counterclaim for a violation of the Fair Debt Collection Practices Act. There's a plethora of federal case law on point. But applying Holden, I arguably could seek to enforce the mortgage. So even though the debt's gone, under the rationalization espoused by the Supreme Court in Holden, I might be able to enforce that mortgage.
Well, let me just stop you very quickly. Do you think that Holden obliterated McFerrin? Or do you think McFerrin still has some validity in the 9th District, realizing, of course, the 9th District did not come down the same way as all the others?
Yes, and here's why. If you read Holden to its logical extreme, as I'm suggesting to the court, that you no longer have to be able to enforce the note, which is what Holden said, because in Holden, the Supreme Court cited 3 prior Supreme Court decisions, and I'll note for the court, the first decision, which was Kern, I believe, it's from the mid-1850s, the Supreme Court said the exact opposite, yet they cited that case for the proposition that a note that's barred by a statute of limitations, the mortgage could still be foreclosed. So if you apply Holden to McFerrin, I think it does obliterate McFerrin. Now, I also have to submit to the court that I think McFerrin runs counter to Schwartzwald because Schwartzwald seemed to suggest it was or, not an and. Now, applying that to this situation, we are McFerrin compliant, Schwartzwald compliant, and Holden compliant because what we actually have in this case is, in addition to the 3 allonges that were attached to the note, we have 3 separate recorded assignments of mortgage, the last of which was recorded well in advance of the commencement of this case. So it doesn't matter which standard this court applies. We comport with every single requirement, both under the UCC, both when it deals with mortgages. And I'm glad you asked the question about the difference between the note and the mortgage. Our position, and my position has always been that a promissory note is negotiable, and it's a negotiable instrument that's governed by the UCC. Absent, there are some limitations if it's a non-negotiable instrument. But generally speaking, notes are going to be governed by and bound by the UCC. Mortgages aren't. Mortgages aren't a negotiable instrument. It's a form of security. It's no different than a security agreement or anything like that. And so
I'm going to need you to wrap up.
So I'd submit to you that regardless of whether this court applies Schwartzwald, McFerrin, or Holden, the evidence in this case supports the finding by the trial court that the judgment was properly obtained. We also believe the appeal should be dismissed as moot. Thank you.
Thank you, Counsel. Counsel, there is just under 3 minutes remaining for rebuttal.
Okay. The defects complained of here occurred at the outset in the Wachovia Cobalt Trust, if you will, transaction. And when you look at the, what was referenced again by counsel, and it was set forth in their Exhibit 29, they relied on it. That's section 2.01A of the pooling and servicing agreement. It says the depositor does hereby assign, sell, transfer, set over, and otherwise convey to the trustee all right, title, and interest in, into, and under the mortgage loan. And mortgage loan caps, so that's all the mortgage loans that were supposed to be pooled. That shows that the depositor had to acquire title to the note in some manner. And that's done by negotiation. Article 3 controls. There's no, and it's their burden. If they can't establish they're a holder, and there's a defect in the allonge at the outset, they have to show that they're a non-holder in possession, and they need to show then all the parties in the chain of title. Here's a party in the chain of title where there's no endorsement to them, there's no endorsement from them to the Cobalt Trust. There's a gap in the chain of title at the outset. The fact that 3 trustees were renamed in after all this occurred, that subsequently transferred by an allonge and transferred by assignment of mortgage, doesn't correct that defect from the outset. Also, it was kind of odd at trial when they spent a lot of time on Exhibit 29 with Mr. Maracas going over their exhibit. And then when cross-examination started, there was an objection to being able to ask, Mr. Maracas any questions about their exhibit and his testimony. So, I mean, I think, there's a waiver which we've, raised as well relative to the standing issue. But I think more recently in 2 cases out of the 10th District, George 1 and George 2, as they're commonly referred to, which we cited to, I think they have a very good discussion about this contractual concept of privity and the lack of privity that would bar a borrower from challenging what happened. We're not challenging what happened. We're not acting as though we're a party to the PSA. We're saying that they have a burden to show how they acquired title, and that shows that they didn't meet that burden. They didn't put on any evidence to show that the depositor received an assignment, an allonge and delivery of the note, and an assignment of the mortgage, and then a corresponding one out of the depositor to the Cobalt Trust. Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.
Thank you.
Thank you.
Thank you, Your Honors.